Legal Dilemmas, where you will find clear, concise legal advice. My name is Brynda.
And my name is Safina.
Safina, today I'm going to ask you a question which has been sent in by one of our viewers. And it relates to consenting to medical treatment for a child. Now, this lady has a 14-year-old and she wants to know if her 14-year-old daughter can consent to medical treatment without her being the mother, without the parents' permission.
It's a really valid question, Brynda, and it depends upon the nature, scope and type of treatment. Because, the law says if you're between the ages of 16 and 17, you can consent to medical treatment for yourself, whether it's surgical, dental or mental health related. You don't need your parents' consent. However, that is different if you are under 16. In those cases, the law looks at whether you are what's called Gillick competent, Brynda. And Gillick competence is essentially based on a case where a mum challenged the Department of Health around the fact that the doctor had given contraceptive advice and treatment to her daughter who was under 16 without her consent. And the court essentially said a child is Gillick competent if they've got sufficient maturity to understand that the treatment that they are having and understanding and maturity of that treatment, then that treatment can be given to them.
Okay, so the same way as consenting, how about refusing? Can a child refuse medical treatment?
Yeah, absolutely. Children can refuse medical treatment depending upon their age. Obviously, we're looking at the same age group that you've just mentioned. But a child under 18 can't refuse medical treatment if it's likely to cause them significant harm. So, for example, if a child needs a blood transfusion, Brynda, or if it's critical medical treatment, like psychiatric treatment that they require, they may need sectioning or something. And in those cases, their wishes and their consent can be overridden with a parent who has parental responsibility, or by the local authority who may have parental responsibility, or an application may have been made by medical professionals who have got concerns around what is happening with the medical consent.
Oh, okay. So that's an interesting response, and I'm hoping this answers the viewer's question that a child can refuse or consent as long as they are Gillick competent. And basically what that means is they need to understand the nature of what they are agreeing or consenting to. So I suppose it would depend upon their emotional maturity and intelligence.
Absolutely, and obviously children mature differently. I mean, some people say that girls are more mature than boys, so that has to be an assessment undertaken by medical professionals, really. As well as other people that are involved within those proceedings. If there are concerns like the parents, you could have CAFCAS at a local authority. Obviously it's different in every case.
Okay, thank you. That was a detailed explanation. If you do have any further questions that you would like us to address, please send them to us in our comment box, and please subscribe, like and share Legal Dilemmas to listen to more great legal content.